Hello and welcome to the Senate Committee on Government Operations Committee meeting of Wednesday, April 9th, 2025. We have for consideration two bills today, both of which are first time running through. And the first one is 472, H472. This is the so-called OPR bill, which is an annual bill that comes to us from the Secretary of State's office. And we have that, and then 474, which is the miscellaneous changes to election law. Between the two bills, I'll just let committee members know, we have 15 witnesses. So if you can limit your questions, that would be great. If you honestly have questions, I don't mean to shortchange anybody in that regard either. And we'll ask each witness to be as quick as they possibly can on it. So I don't see our first witness. I don't think. Are they on Zoom? I don't think anyone's on Zoom. I was hoping maybe Tim, if you want to walk us through the OPR bill, that'd be great.
Absolutely. Good afternoon, committee members. Thank you very much for having me. And for the record, my name is Tim Devlin, Legislative Counsel. This
is our first one.
Yeah,
Sure, have copies of it on your desk.
indeed. This is the committee's first walkthrough from our office, I believe, of H472. Version has passed by the House. That is an act relating to professions and occupations regulated by the Office of Professional Regulations, or the OPR miscellaneous bill.
Should we look at the official or the unofficial version?
You should have as passed by the House.
Oh, I was just,
It's the unofficial because it doesn't have any red line.
great, okay, thank you.
So, let's see. Beginning at the top, we have first part of this bill pertains to OPR fees and fund management. Although I should note that there are fees scattered across various parts of this bill. Section 1 will amend 3 VSA 118. That is collection and disposition of revenue. And we'll see the first amendment made at the bottom of page 1, specifically to subsection C, which shall read, the Secretary of State shall have the authority to collect and deposit into the Secretary of State Service Fund revenues generated from optional services offered in the normal course of business, including for one-time or periodic sales of data by subscription, other contractual basis. Section 2 will amend previous sections 125, that is fees. And here we have some alterations to absolute numbers as well as the creation of new fees. So first one will appear in subsection A, subdivision 1. For the verification of license will change from $20 to $30. Under B, unless otherwise provided by law, the following fee shall apply to all professions regulated by the director in consultation with the advisor appointees under Title 26. For W, under biennial renewal, which is accepted here, for electrology shops shall be $200. Then under subdivision 9, there's a new partnership application fee of $50. Under subdivision 10.
So these are all new fees, not changes to existing fees.
Let's see, that is 4W, 9, 10, and 11 indeed are new. The one above, under I is modification.
Okay.
Let's see, subdivision 10, specialty or endorsement to existing licensed application, $100. Subdivision 11, disciplinary action surcharge, $250. And we'll get to the disciplinary action surcharge a little later on. Breaking across the page to top of page 3, we have the removal of subsection C, which did read, notwithstanding any provisions of law to the contrary, the board shall not require payment of renewal fees 4 years during which a license requires.
So would this say, for instance, I leave the social work field because I had a baby. I'm raising kids. I'm out of the field for 5 years till my kids go off to kindergarten. Now I'm coming back. I have to pay for the 5 years that I was home raising my child.
I will defer to Secretary of State's office and OPR to provide you maybe a better understanding of what would happen on the ground right
Okay.
there.
But that's not what this language says, is any year that that I've let my license lapse, I have to pay for that when I get it renewed.
I believe there is kind of, let's see, term, I apologize, the exact wording's evading me at the moment.
That's okay.
But indeed, this would permit but not require, essentially, if license lapsed, and fees are not paid properly versus, voluntary suspension or maybe other circumstances,
Okay.
which may not fall under lapse, then indeed, the arrears, kind of, if you would, could be collected
Okay.
for reissuance of license. But again,
Helpful.
depending on what is lapsed, and what that typically looks like, I'll defer to OPR.
Okay, thanks.
Next part of the bill has to do with 2027 fee increases, peer support providers. Section 3 will amend 3 VSA, section 125. This is fees similar. And we have, let's see. Subdivision B 4 V, or sorry, 5. And this is an exception to the biennial renewal, which is typically $275, but for peer support providers or peer recovery support specialists, it's $50, now being changed to $75. Next part of the bill has to do with OPR duties and disciplinary authority. Section 4 will amend 3 VSA, section 1.3, titled duties of office. In particular, subdivision K2, and also subsequent M, created them. So K2, and let me just read K for context of deliver to. For any profession attached to it, the office shall provide pre-application determination of the individual's criminal background. This determination shall not be binding on the office and in a future applications if the individual violates probation and parole or convicted of another crime following the determination. This is that kind of pre-screen of applications. Subdivision 2 under that language creates this individual shall submit his request online, accompanied by the fee for pre-application determinations set forth in section 1.5 of the subchapter. And now we'll remove this following sentence reading, if the individual thereafter applies for licensure, this pre-application fee shall be deducted from that license application fee. The new subsection M will be added, reading the provisions of subsection 116A, subsection B for this title, shall not apply to the office. If, the office shall utilize the procedures within 26 VSA, chapter 57 to review whether regulation of the profession is still necessary. Section 5 will amend 3 VSA, section 127, that is unauthorized practice. And the amendment in section 5, the next page of 5, this is under subdivision B 2A. And here we are talking about civil penalties, but different piece. The Attorney General or an attorney signed by the Office of Professional Regulation may elect to bring an action seeking only a civil penalty of not more than changing it from $2,500 to $5,000 for practicing or permitting the practice of regulated professions without authority before the board having regulatory authority over the profession or before an administrative law officer. So the idea of practicing without licensure.
Do you know what the 2,500 was set at? 2,500?
Why it was
When?
I'd have to take a look at the revision history of that statute. I could look at it.
Thank you.
Get that to you. Section 6.
Yeah, just build on that,
Sure.
which I think it would be helpful to know. I mean, as we did in Ways and Means, we always looked at the fee schedule. And when they were last updated, when we used to have a fee bill every 3 years on every subject, we had a notion. But, I think we haven't raised some of these for a while. So it'd be really useful to know on all these fees when the last time was we raised.
I think we can look at that. To look into, just to give you a brief but not necessarily informative answer, Senator Bobowski, this was last modified in June 6, 2024, but it's also modified in 23, 19, 17, 15.
Huh.
It's commonly modified, but that doesn't tell us when that particular bit of language was modified, so we'd have to do some statutory research on that.
Or many of this will be.
Yeah, more likely, yeah, with the idea to tell you exactly what that certainty. Section, let's see.
Maybe if you just go through the changes.
Sure. So, looking at section 6, and now we're at DPSA 1.9, powers of boards for director and advisory professions disciplinary process. We need a change that can be found at the top of page 6. Which will read, after a finding of unprofessional conduct, the respondent shall pay his disciplinary action surcharge pursuant to subdivision 125(12) of this title. The proceeds from the disciplinary action surcharge shall be deposited in the professional regulatory fee fund. And this is what I was referring to earlier on in the bill, which was at the bottom of page 2, that disciplinary action surcharge is $250. So,
Yes.
and now we move on to the part of the bill having to do with cosmetology's certificate of approval. This is in section 7, which modifies 27 PSA 281. And here we have a new language in A4, and which reads, School of Barbering and Cosmetology shall not be granted a certificate of approval unless the school, amongst other things, 4, requires a school term of training consistent with formal training requirements established by rule, et cetera, until we get to the additional requirements of and training on the care, styling, and treatment of textured hair. For purpose of the subdivision, quote, textured hair, and quote, means hair that is coiled, curly, or wavy. The training on the care, styling, and treatment of textured hair shall include A, is now breaking to page 7.
No.
Techniques for cutting, styling, and chemical treatments for textured hair. B, knowledge of products and tools specifically designed for textured hair. C, best practices for hair health and scalp care for clients with textured hair. And D, cultural competency and historical education for the significance of textured hair in diverse communities.
Senator White.
I just want to say that's beautifully written. And I'm wondering if textured hair, the reason you're explaining the definition is because it's not defined somewhere else. Is that the case?
I believe so.
Okay, thank you.
I mean,
A very important addition to our conversation in this field.
I
So,
guess, but almost everybody has curly or, I mean, I know we're trying to get a particular group, but I mean, still, it's like sort of basic that we would do this.
It's gotta be me.
We have things that address down there too.
Next part of the bill has to do with nursing assistants and license renewal. Section 8 in particular will amend 26 PSA 1645 and adding a new subsection and subdivision C1 and C2. Reading, just to orient the committee, we're at the bottom of page 7, page 8. Licensee seeking to renew an expired or lapsed license after fewer than 5 years of absence from practice shall repeat and pass the competency examination approved by the Department of Disabilities, Aging, and Independent Living for license renewal. 2.
can I just ask real quick?
Yeah.
You wouldn't need to pay the fee if you did this.
Let's see, I shall repeat and pass, this
It's just
is
for assistance.
to, so sorry, in your,
Oh.
like, where you're failed to pass, and then what the question?
No,
is,
so
is that-
earlier
or-
the senator had asked about, do you need to pay the fee if you have a lapsed
Oh,
license?
right, sorry.
And now I'm understanding this is not for everyone, this is just for nursing assistants. So the assumption is maybe that you would need to pay the fee in the other instances, but I understand what you're doing.
Into two distinct issues. 2 at the top of page 8 A licensee who does not pass the competency examination shall repeat the nursing assistant education program and competency examination.
Okay.
Next part of the bill has to do with repeals, funeral service escrow agents, and motor vehicle racing. Section 9. And this is essentially just a list of areas that are regulated by OPR. We have the removal of motor vehicle racing. I'll explain.
Okay, so what happens now? Who's regulating more motor vehicle racing?
Okay,
No, you're not. They're saying they're not regulating it.
Maybe it's in another section.
No, this is indeed removing regulation of motor vehicle racing as it currently exists by OPR. I'll let them speak to
Who it goes to, because it needs to be overseen by somebody, doesn't it?
Yes.
Hey, look, if
we'll have a testimony from.
we're overseeing people who destroy themselves in little cages, we certainly should be overseeing race it's
As this bill is drafted, it does not transfer oversight or any sort of regulation to it.
I believe you'll find the insurance industry is pretty vigilant in that regard.
they manage it in another
Okay,
way.
I'm flagging for more conversation later.
Section 10
Mhm.
will amend 26 VSA 1272 as rules prepared prepaid funeral funds. And we have on page 9, the removal of subdivision 2. And what is being removed reads the appointment of an escrow agent who may be a bank or other category of individual, such as an attorney, a local elected official, next of kin, or the executor of a buyer's estate. All prepaid arrangement funds shall be paid directly to the escrow agent and not to the funeral director of the establishment. And it's important to realize that this is not a prohibition on this. It's just no longer requiring the appointment of the escrow agent here in the instance of having prepaid funeral.
Yes, Senator Clark.
So just now the directors of the funeral homes are doing it?
I again have
Okay.
to how it looks on the ground. I prefer to OPR.
Or to follow using it.
Section 11 is repeal section. This is section 11, but does repeal two. It's not section 11. I should just say it repeals 2 statutory sections, which should now kind of ring familiar. A,
No, okay, yeah.
26 VSA 1275, prepaid funeral expenses and duties of escrow agents is repealed. And B, 26 VSA chapter 93, motor vehicle racing is repealed. And just so the community is aware, this is the entire chapter. There's much more language here. If wanted, our office can provide that to you. But just for keeping line with our drafting guidelines, we just simply state what's being repealed here. The next part of the bill has to do with position, executive officer for the regulation of mental health professions. Section 10 is session law, titled Office of Professional Regulation Position Appropriation. And will A, create a new position, one new permanent full-time exempt executive officer for the regulation of mental health professions. Be created in the Office of Professional Regulation. B, sum of $170,000 is appropriated to the Office of Professional Regulation from the general fund in the fiscal year 2026 for the creation of the positions of the executive officer. And then it was the R, and then let's see, bring to page 10. Probably go ahead and do a report of massage therapy establishments. Section 13 is also session law, titled Office of Professional Regulation report. That's sorry, massage therapy establishments. On or before November 15th, 2025, the Office of Professional Regulation in consultation with interested stakeholders shall submit to the House Committee on Government Operations and Military Affairs. And this committee proposed legislation for the regulation of massage therapy establishments as defined in 26 VSA section 5401 2A. Bring us to effective dates with section 14. This act shall take effect on July 1st, 2025, except that section 3, from beginning with fees or peer support providers, shall take effect on July 1st, 2027.
Questions for Attorney Devlin? Okay, you're off the hook. Thank you, very much appreciated. Let me invite Representative Kate Each to come up from the House Committee on Government Operations. She reported the bill. And welcome, Kate. It's good to see you.
Before she begins, may I just point of personal privilege? The two of us just sang a rock these green hills for the devotion on that. So, and it is a pleasure to sing soprano with you.
Well, thank you.
Okay. So we've just had the walkthrough and we did have some questions. I think those will be addressed by Lauren when we get, and Jen perhaps, when we get them in the chair. But if I could ask you what the committee vote on the bill was and also the floor vote.
Sure thing. Committee vote was 8-1. And the board was a voice vote in favor.
Okay.
A voice vote.
Yes, as far as I remember, and
Wasn't a roll call.
that's correct.
You could, well, maybe you can't see because you don't have our agenda. Whether we should probably have other folks come in to testify or suggest folks that you had come in house that we might not have thought of. That would be great.
We mostly worked with the Secretary of State's office, I
Yeah.
would say, and that was
Okay.
really helpful. So yeah, depending on what questions we want.
I think most of them can be handled by the OPR folks. Senator White?
Did you hear from any folks in the, I think the electrolysis profession?
No.
Oh, okay. Did you hear from anyone in relationship to the expanded scope around hair care and textured hair?
We do not.
Okay.
Did you hear from anyone in the peer support professions?
Yep. I can tell you who I heard from if that's helpful.
Oh, how about beginning with the positive? Who you did here?
Yeah.
That we can surmise who she didn't.
Legislative council, obviously, OPR. We did hear from the manager of the Regulatory Affairs American Massage Therapy Association and the Director of Government Affairs from Down Martin and the Director of National Association of Social Workers and Fiscal Animals.
So, without putting you on the spot, to characterize the two no votes in committee, would it be fair to assume that some of that pushback came from the increase in fees? And again, I don't want
Put words in people's
to,
mouths.
yeah,
Maybe.
I'm just kind of curious whether that seemed to be the case. And if you'd rather answer, I'm perfectly comfortable with that. I mean, I can do some further investigation to find out who it was that asked them, but
Yeah, maybe it's better if I don't try to
okay,
say what the reasons were. But
yeah, okay. Senator Clarkson.
And going into this, we've had a sunrise. We did a lot of work on massage therapy. So that was kind of teed up. That was ready to go. We've done a lot of work on actually all these pieces, I believe. And so in some ways, this is a very simple OPR bill, I think. Given you've worked on it.
I know the connotation of that word in this building, so
You mean simple little bill?
Yeah,
I didn't say it was a simple little bill. I just said
that's true.
it's, and certainly we're going to add something that's less simple, I hope. So we have done a lot of the background work to the pieces here, which I think we just need to remind ourselves.
I think, not to put words in Senator Clarkson's mouth, in contrast to previous OPR bills, this seemed a little bit more streamlined. If I,
And this is why he's the chair.
Well.
And I
you're in chair.
am, but not here.
Okay, we're diverging here. Kate, did you have anything else to offer to us on the bill? Okay,
No.
and this is unfortunately, in some ways, the last vehicle we have to potentially move another bill that didn't make crossover. So I don't know how that will affect. If it gets put in, it'll go back to you and
And we'll have a robust discussion.
we'll see how things go.
If it's the one I think it is,
Yeah, well,
I said earlier.
yeah, S-119. We're not
yeah.
trying to be deviant here.
So was
Hi.
there a House bill? Is there a House bill also? And there was, you didn't.
I don't think they took it up.
Well, also you were doing the election, they had a lot of other big things.
Yeah.
I'm not disparaging the work of the other body. Senator White.
Can I just ask if you want to give a little bit of info around the removal of race
Yeah.
regulation? I don't know, just it would be nice to hear something about that.
Well, what I know about it is that we're one of very few states that regulate it currently, and that the insurance industry covers it just fine.
There was a Sunrise report done as well, which came to the same conclusion. So I happen to have a personal interest in that. Devil's Bowl Speedways in Rutland County, and they've been in essence overseen by two groups for a number of years. And apparently would prefer to have one, and the insurance industry, as I understand, is much more tightly controlling of this. So I'm in favor of seeing it not be in the purview of the OPR, but that's just my
Okay.
opinion. I think they did due diligence for the Sunrise report and came to that.
Okay.
thing.
I'll look out for a copy. I'll try to get a copy
Okay.
of that Sunrise,
That's fair. Sure.
perhaps.
Yes.
And at some point when we have more time, not today, it would be interesting to understand and appreciate the interplay between the insurance industry regulating things, some of which is to me much more dangerous and violent than motor race car driving that we regulate under OPR. So I'm very interested because that strikes me as something that the insurance industry ought to be very keen on. And so and there are other industries that there are other things that OPR regulates that one might also have those questions about why doesn't insurance regulate?
Okay, we can certainly investigate. Okay, thank you very much.
Thank you.
I guess you're up, Lauren, if you'd like to be.
I would like to be. I'm gonna bring Mike Warren up.
Sure.
Thanks, Kay.
Thank you.
Take care.
Good afternoon. For the record, Lauren Hibbert, Deputy Secretary of State, and I have with me.
Michael Warren, interim director at OPR.
Let's see again.
Thank you so much for having us here to testify about the OPR bill this year. The OPR bill had some very simple goals, and as you guys have noticed, it's a streamlined bill. That was our intent. We really had some other things in the fire, as you know, so we wanted to be able to focus on those other items and just focused this OPR bill on the things that we thought would be necessary to change this year. So there's buckets of work that are in this bill. One, obviously deregulating motor vehicle racing. We did a sunset report on that. We were asked to do a sunset. It's the other half of the sunrise. So Mike will talk a little bit about the findings of the sunset. So that was one piece that we wanted to get done. We also wanted to charge fees for voluntary services where OPR has not charged fees before. So in answer to your question, Senator Clarkson, some of the fees are totally new. They're new fees. We haven't charged for them before.
Right, which Tanya pointed out earlier that they're not underlined. I mean, there's nothing,
Right.
they're brand new out of it.
They're brand new. Some of them are fixes to legislative mistakes. So for instance, the electrology shop and the peer support renewal, both of those fees are fixes to previous legislative mistakes where the electrology shop fee was dropped entirely when we did a fee bill in 2019. So we have not had authorization to charge for an electrology shop for 2 renewal cycles. So we need to have that fee added back in. And the peer support, the peer application fee and the renewal fee were both supposed to increase in 2027. And for whatever reason, that did not happen to the renewal fee. It did happen to the application fee, but not to the renewal fee. So those were fixes to previous legislative mistakes, probably mine. But
We don't need to blame.
we don't need to blame, but that happens to both of those. So those are the primary goals for this bill. And then we'll talk about the specific provisions. I'm going to turn it over to Mike.
Sure.
Oh, actually, I'm going to talk about section 1.
Sure.
So section 1 is a new a new authorization for the Secretary of State to charge a fee, a revenue fee, under our general provisions, so higher than OPR, to provide a fee for data feeds. We are currently providing data feeds to a lot of people within the OPR space, including the hospital system, other regulatory boards, associations of regulatory boards, about all of our licensing data. So UVM's a great example. Every day they receive a file from our office with all of the healthcare licensees and their license status, whether they're active, inactive, suspended, revoked. And they compare that with the people they have working to make sure that everyone they have working is appropriately licensed. This is really important to them because otherwise they do not get adequate reimbursement from Medicaid, Medicare. The feds really care a lot about whether or not someone's appropriately licensed before they pay for insurance claims. And so when we developed our new system in 2017, UVM, among others, that's just one example, asked us to develop this feature. We have done so at no cost to UVM. And this is a huge benefit to UVM. Essentially, as you guys know, I don't need to go into deep discussion about it, but the Office of Professional Regulation has been at a deficit now for many years. And so one of the goals of this bill is to generate some revenue for things that we've previously done for free, so that we are not continuing to go deeper into the hole. And when we do not charge for things that people are asking us to do, that means that we have to consider and raising fees on licensees. So for instance, it does not feel fair that UVM is getting this data feed that we're going to continue to build it and create it for them at no cost. And that cost would then be transferred to our licensee population. We'd rather be able to put that onto the individuals who are asking us for that. We are going to do this by policy, so that you'll see in the section language in 3 VSA 118 that we're going to create a policy because the cost for the state to doing this really depends on how often we're doing it and how much customization is required. So if it's a lot of customization, it should have more cost. So we were asking for the authority to establish the structure of the revenue by policy. And we're asking for it to be above the Office of Professional Regulation in the general sections related to the Secretary of State, because we anticipate, actually, we know that there are individuals in the business services world that want these types of data feeds. And so we would want the authority to charge them as well. So happy to take a look on that second.
Thank you, Ms. In the situation where you have a mailer that's going out to a specific license population, I mean, I feel like my dad gets letters about being a plumber all the time, and I don't know how they know he's a plumber. Maybe he signed up for something, but do you guys share that kind of information? If there's all the electricians in Vermont, here's their information, and would you now be charging folks for that? Because I'm in favor of that, but I'm just trying to think of another example. Is that what you mean by business services? Like people sending out mailers or advertising to that client, that specific licensing?
I think that there is two things happening there. One, if it's letters from the state and it's to plumbers or electricians, that's not us. That's the public safety and fire safety. So we don't regulate your dad as a plumber.
Oh, okay, good point.
But yes, there is, we are asked for our data all the time, rosters of all of our licensees, and your bond actually was passed in S28. It's currently over on the House side now. That was the reproductive and gender protected healthcare, legally protected healthcare is the right term, bill, that the state for all licensing entities will only disclose the public address for a licensee and not the telephone number or email address. And we asked for that because we are seeing instances where our data is being used to harass and annoy licensees, but also to send a lot of unsolicited, advertisements.
Yeah.
We do think that the public address is appropriate to be released, but it used to be that we had to release. We always held back the telephone number because there's in the Public Records Act, there's something that allows us to redact information that could be used to harass and annoy, but with the email address, we could not figure out a solid legal argument to withhold, but we have asked to be able to do that, and the Senate did pass that, and it looks like the House supports that at this point.
I totally support that. I appreciate that, but and so that situation will be totally different. These are really like for large employers for
Large employers or the Association of Nurse Regulatory Bodies asks for this data feed. We have a couple of other associations. The federal government asks for this data feed for real estate appraisers because of the Fannie Mae, Freddie Mac
Oh, okay, yeah.
scenario.
Mhm.
So we have a couple of entities that are asking for this.
Okay.
And this does occur in other states. They have a model for this. We just have we've never had the authority to charge for it. We've always been doing it for free. Our budget status in 2017 was very different than it is now. And we think that those entities should pay for the data.
I think that's really smart, actually. I think that's a very ingenious way to help get at that without raising licensing fees. The reason I asked the question was I was mildly concerned that when you make something profitable for anyone, you then can. So I appreciate that. It sounds like you're in the exact opposite direction, in fact, that you want to protect your licensees' information, and it's only in very specific arrangements that you could see with large entities.
And these data feeds will only be what's public.
Okay.
So right now, I don't know whether any of them have the email address in the data feed, but if they do, we'll take that out. As soon as that bill passes.
That is really, and we should support that.
Yeah, you're welcome.
Senator Jackson.
There will be an interesting intersection between the data bill that has just come from the House that addresses public safety, protecting vital, key contact information.
Yes.
Yeah.
Public safety, Daniel's law bill,
Yes.
so maybe a little
I
bit.
have been watching that.
Yeah, no, it has implications here, I think.
Yes.
Okay. Great.
So next is section 3 VSA 125, section 125. And this involves license verification fees. So currently the fees are $20 and we're looking to raise that to $30. License verifications, these are for people that are licensed in Vermont and they're looking to be licensed in other states. This is independent of somebody who might be part of a multi-state license or a compact. This would be somebody who's single license here and going to a state that has another single license. And in order to go to those states, they need an official verification from our office. So we're asking that the fee for this be raised from $20 to $30. And if somebody is applying to be licensed in multiple states, then that would apply, for each state that they're doing that in. Currently we charge 20 and we're looking to have that raised to 30. Somebody can currently go to our website and they can do an online search. They can look to see if somebody's licensed, but this is slightly different because the state that they're going to get licensure from is actually looking for an official verification from our office rather than the online verification. Any questions about that at all?
Is it like an actual certificate that they get and can mail out or?
There's a form that has to be filled out by us and sent to
Okay.
the state.
Great.
And it takes staff time to do it, and that's why we're looking to increase the fee.
But again, a lot more expensive.
Yeah, like Deputy Secretary said, it's small little pieces, but we're looking to try to get, every little bit that we can to try and help with the deficit.
Yes.
Against one of those.
And also I just might point out, we have more of these multi-state, interstate compacts and it's costing us money because our fees are impacted by that too. So this is a tiny way to help support some of that loss.
I'm sure you will hear from joint fiscal, but there was a fiscal note down on this bill.
Oh, okay, we should get it. Maybe we have it. I bet Jillian will have it in 2 seconds.
Okay,
Name it, she finds it.
again, under three VSA one, section 125, this is B4W. And this reestablishes the electrology shop fee. I think Lauren already spoke to this. This was inadvertently left out of the fee bill in 2019. We're just looking to get this back so we can charge those shops back again. So all shops with cosmetology shops, different types of shops that we license. There's a shop that has a license and a fee for that. And then the individuals that work there that are licensed also have their own. So this is just for the electrology shop fee, the electrologists. That's already been.
Have you gotten any feedback or pushback from folks in that space? In other words, I don't want to put it the wrong way, but they've managed to not have to pay. I don't want to say got away with, but
They did.
for years.
Happy accident for them.
And now, so it's like going from 0 to 60 and all of a sudden, oh, what are we doing?
So we have,
Okay.
so there's a default fee if it's not specifically named, and the default fee was established at $240 in 2019, and we were going to charge them the $240, and the community of electrology shops, of which there are about 30 or 32.
What is electron?
Electrology is a process traditionally whereby you put electricity through a needle into a hair follicle and it kills the hair follicle. It's a hair
Removes
removal
hair.
technique.
Oh,
They also have the authorization to do laser if they have.
no,
required
that is a
treatment.
great, okay, I
Why did you want
understand. You, maybe there's,
Okay.
There's lots of reasons why people do electrology, but I'm happy to talk about it. It's very important it's very important for gender affirming care and for anyone who might have a middle-aged mustache.
Enough said.
Yeah. I just made myself blush.
And me, thank you. But you didn't even talk about bikini.
Oh my God.
No,
Allison, we're moving on.
Keep saying that we just make.
Oh, so in any case, we heard from that community.
Yep.
And we have been intending to fix this. And so we waived charging the standard fee in 2 renewal cycles and committed to the community that we would be fixing it and that we would do under the standard amount. We set 200 because that's on par with other similar regulated activities by us. And we think that is fair. Mike is right. We license several different types of shops. The important piece there is we are required to inspect them. So when we license a shop entity, there is a cost for us of enforcement and inspection.
Okay.
Great. The next section is B9 through 11, and these are new fees for services that OPR currently offers for free. So in section B9, this would be a charge of $50 for an apprenticeship application. So currently we don't charge anything for an apprenticeship application. There are several professions, tattoo is one of them. Cosmetology also has an apprentice. So somebody can complete an apprenticeship application. There's a process that our office has to go through to review the application. They have to put together a plan for how they're going to do the apprenticeship, how they're going to provide the necessary training and all the different categories that are required for the training. And we have to review that. We have to make a determination whether or not that's sufficient to provide the education that they're going to need to have and meet the qualifications of licensure. And we've been doing this for free. In all those professions. And so we're looking to do a $50 apprenticeship application. Again, it's a small part, but it does take work for the licensing administrative staff to go through and review these, oftentimes with general counsel and the licensing supervisors to do that. So it's just to help us compensate for the time associated with that.
If I could just add, this is someone chooses this path instead of going through formal education. So they, instead of going to cosmetology school, they choose to be an apprentice. So it is still a much, 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 much lower cost pathway.
$50, 90,000. $50, 90,000.
I don't think we have anyone at 90,000, but yes.
No, but I mean, that's Dartmouth now is.
I wonder that Dartmouth is offering cosmetology school.
No, but her point is, this is a very reasonable way to enter a
I
profession.
understand that.
Yeah.
And we are on the other end of the scale. Outrageous.
Well, and in lieu of them getting the education and us being able to look and see that they've been formally educated, we have to really review all the paperwork to determine will they meet the requirements after going through this, and oftentimes there's back and forth to make sure that they have the required needs. So yeah, it does take time by our office. Section B10, this creates a specialty license fee that would be assessed at the application and the renewal. And a specialty is something that unlocks an additional privilege on top of somebody's license. Somebody could be licensed and then they get a privilege to prescribe. And so that could be a specialty privilege that's on top of, they have to show that they have the additional training and requirements and education, but it would be a fee for the specialty that's attached to the license. And it would be charged at the time of the application. It takes time for us to review the initial application for the qualifications. There's usually continuing education requirements that we have to review each year to make sure they're still meeting the requirements and that they still meet the standards for us to continue to give them that specialty. And this specialty license fee would compensate us for the time associated with that. Section B11, this section establishes disciplinary action surcharge of $250. So this is a new surcharge. It's against practitioners who have been through the entire enforcement process. There's been due process. At the end of the enforcement process, an administrative law officer or board has determined that there was unprofessional conduct, and then this surcharge is something that we would like to be charging these folks who have used the services of our office, the investigators, the enforcement folks, the case managers, to try to help recoup some of the cost of enforcement. The enforcement division in our office, which is where I came from prior to being the interim director, is a very expensive part of OPR. There's investigators, there's prosecutors, there's case managers, we have a paralegal. And so this is a way of trying to put some of the cost of the enforcement on the people who are using the services of the enforcement group. And this is a new fee that we would be looking to surcharge that we would be looking to.
Senator Vygotsky.
So we're having a lot of conversations in judiciary about moving away from this exact type of thing because it is putting, at least in that space, we're often asking people with least stability to pay who have already been charged fines and already have legal fees to pay. I mean, this is why we have a decrease in the Crime Victim Services Special Fund, is because we are actually having a lot of conversation around equity about moving away from this practice. So I got some concerns after all of those conversations about sitting over here and saying, actually, we're going to move towards this practice.
So I understand those concerns and I think they're well rooted, particularly in the criminal justice system. This is a little bit different. These are licensed professionals who are ostensibly making a much better salary than most people involved in the criminal justice system. Not always, but quite frequently. And the cost of this does not come out of the general fund. The cost for operating this system comes out of a special fund paid for by licensees. So when there's a bunch of folks who are committing unprofessional conduct, the cost of all of that enforcement is on the other people in that regulatory field. And this in no way covers the entire cost of enforcement. Quite frankly, I think it costs about a 20th, but it is a way for us to start to recoup a little bit of this money. And we will obviously give time for people to pay. And as we always do, we will be flexible on all of this. We do charge fines currently related to professional conduct. And this is a surcharge for having.
Are there a bunch of people committing unprofessional conduct? What are the numbers?
Oh, yes, there are. We receive about between 600 to 800 complaints a year. We investigate about 500 of those. If in the 800 camp, about little over 2/3, and we prosecute about 1/3 of the cases that we investigate. And that is a substantial cost. And those are cases that are death resulting, sexual misconduct, drug diversion. Many of them are criminal in nature, but also many of them are really significant failing to abide by the standards of practice cases.
And of the third that you prosecute, how many are actually disciplined?
I would say 95% of those.
Wow.
We are very
Oh,
we're very cautious about who we prosecute. We actually are, I think, I'm sitting next to Mike, who most previously was the chief investigator, and Jen, who was most previously the chief prosecutor. I was a chief prosecutor at OPR before I was general counsel and before I was deputy. So we have really focused on educating people, trying to get people into compliance through a whole bunch of other ways. But the cases that we litigate are frequently against some of Vermonters' most vulnerable, but also are significant violations of trust. The reason why we license anybody in the state is because there's an imbalance of information, right? The person who's licensed has a lot more information than the person they're providing care to. That's the underpinning of why we do licensing. And that's why the public needs to be protected. And if you're licensed in any capacity at OPR, there's been a determination that you need to be because you could pose danger. And the cases that we prosecute are where they're at.
right. I've watched some of these cases and been involved with.
They're usually extremely interesting to watch. And we have been impacted, like many other spaces, by opioid addiction for sure. But also, I would say our next biggest significant space of investigations is sexual misconduct or sexual boundaries, and then abuse and neglect. It's probably in that order. And some financial. Yeah.
Okay, Mike?
Well, yeah.
The next section C, this is striking, we'd like to strike the entire provision of this is 125, previous A, section 125, section C. And currently what that section says is that we shall not charge payment of renewal fees for years during which a license has lapsed. And we're looking to strike that. This would be for people who have been practicing during that time frame. So several years ago, legislation changed and allowed an exemption. It used to be that if your license lapsed and you had been practicing for 3 weeks, a month and a half, and you had forgot to renew your license, we would open up a complaint and we would prosecute for practicing without a license. It changed in the legislation. So now somebody has up to 2 years, in essence, to renew before it becomes a complaint that we would open and do an investigation where we would sanction them. And so during that time period that somebody hasn't renewed, but if they have been practicing, we charge them for having practiced during that time. It's a prorated, fee, basically the reinstatement fee, and then plus for the time that they've been practicing. And so with this provision in here saying that we shall not charge, it doesn't really allow us to do that. So we're looking to have that stricken. Again, only for the people that are practicing during that time. So if somebody lapsed and they weren't practicing and they just want to renew, we wouldn't charge them a fee for that. And that could go, months or even years. Sometimes people might take some time off for a year or two. And then as long as they have the qualifications, some professions require continuing education or the things, as long as they still meet the requirements, then they just pay to renew their license at that time.
Okay.
So we're looking to have that stricken.
So Senator Lahosky, your example, you would not pay to come back into the profession because you were not practicing. But if you allowed your license to lapse and you continued to practice up to 2 years, we have a fee schedule for that. And then after 2 years, we prosecute you for unlicensed practice.
Okay. The next section, 125B45, this section adjusts the renewal fee for peer support providers and peer support recovery specialists. peer recovery support specialist, sorry. The renewal fee was intended to increase from 50 to 75. And when the original legislation was enacted, but the fee never made it into the fee bill. So we always have an initial application fee, and then the renewal fee is always different. So in this case, the application fee was 50 and the renewal was set to be 75. It just didn't get in there, so the renewal is 50, which is out of line with the other professions that we have where we have the same fee structure. So we're looking to have that just amended.
And again, that would be effective in 2027, which was the intent of the original.
Right.
The next is second chance determination fee. So this is section 123 and it amends the duties of OPR in the following subparts. So currently, if somebody has a criminal history and they're not sure whether they would ever be able to be licensed by our office, we have this program called the second chance determination, last chance determination. And so they can come to our office, they can bring us copies of their criminal history, they can ask us to review the information, and we can make a determination based on your criminal history. This would not prevent you from being licensed. And so then they can go ahead and start whatever schooling or get whatever education they need, and they don't have to worry that they got the education just to later find out that the criminal history prevents them. So
We're done.
yeah.
This was a big bill in 2019.
Yeah. It's
Seniors lost the electrologist.
Yeah. This was a good one to get. I mean, when you think about people that are trying to get into the workforce, the last thing we want is for them to go through all this to get to some place where they then can't, and so this is a good program for us. What we've traditionally done is we charge the $25 fee, we review all of the information, and then when they get licensed, we give the feedback. And in this case, we're just asking that we keep the fee and not refund it, because it does take a lot of work from the licensing administrators, the general counsel in our office, the attorneys. The documents get floated around, everybody kind of weighs in, so there's a lot of staff time for that. It is a very small fee, and again, it's not going to significantly help. It's not every little bit counts, and so we would just ask that we don't have to return that fee at that time. That covered everything on that.
Yeah. Can we talk about this one?
Yeah, section 5. Yeah.
Okay, so there was a bill, the Boards and Commissions bill a couple of years ago, that required every if there wasn't statutory change, it's now in 3 VSA 116 AB1, and it requires that if a board or commission statutory language is not modified or addressed within a 5-year period, the board automatically sunsets. That makes sense for some of our boards. It does not make sense for OPR boards because we don't want to change the statutes in all of our professions every 5 years. That would mean that we'd have to be paying attention to, did we change the Board of Chiropractic's language in the last 5 years? There may not be any reason to change the Board of Chiropractic's language. And also it doesn't make sense on a policy level because we have the sunset provisions, because we are required to proactively monitor our board and sunset them. So we think that this is an appropriate policy exemption to the Boards and Commissions bill, and we're asking for it.
Next is section 127B2A, and this raises the administrative penalty for unauthorized practice from $2,500 to a maximum of $5,000, and this is consistent with the penalty allowed to be pursued in Superior Court. So unauthorized practice is when somebody is practicing a profession without a license to do so. And in some of the cases that we have, people failed, as I spoke earlier, people have up to 2 years, and sometimes people will not renew for 2 or 3 years. That is still considered unauthorized practice. But we also have cases where people practice a profession knowing that they're not licensed to do so. They do it anyway. And because they're not licensed by our office, and they may never intend to be licensed by our office, the only thing that we can do is charge them with unauthorized practice, and this allows us to raise that administrative penalty from 2,500 to 5,000 to be more consistent. Does anybody have questions about that?
That would be a singular situation, right? So it wouldn't be the Attorney General and someone from OPR both charging 5,000.
That's correct.
Okay,
We can pursue those actions either administratively or in Superior
Alright.
Court.
okay.
That doesn't mean that someone couldn't also be charged criminally. So a very, standard case is an unlicensed tattooist. We have probably 3 or 4 of those a year. That person may be charged criminally for unlicensed tattooing. But also we would seek, to be charged, that they would be charged with unauthorized practice in Superior Court or in the administrative law process. We prefer the administrative law process because it's more streamlined. That case really doesn't need to be part of the court system. But we would like to get the same fee that they could be charged in Superior Court. And the rationale for this fee is this is someone who never paid any licensing fees. So the
Right.
work of investigation, the work of investigation and prosecution should be paid for by the person who committed that.
So we're starting to back up here. Let me suggest if committee members had questions, remember when we walked through it with Tim, you could now ask, folks from OPR. Because we've already had the walkthrough to go through each of the changes.
Yeah, I have no questions of OPR other than the motor vehicle racing sunset report, but I'm happy to review that on my own time. Because I know it's 2:30.
For return to the OPR bill.
Oh, sure.
Yeah, so I mean.
Yeah, we would like the opportunity.
to add.
Of course. And I don't mean to cut you off.
No. I think you're cutting us off for something, my other baby. So, it's okay. But we would like to talk about the Title 26 provisions. There are some really important things to our office. So, if and when it's possible, we'd love to come back and talk about those.
Sure. Yeah, we have it on the agenda for next week again.
Sounds phenomenal.
Okay. Thank you very much, Mike.
Yep, thank you very much. Appreciate it.
You still enjoying yourself as interim?
Sure.
That's
Yes, I am.
great pillars of support.
Yes.
So let me give the committee a 10-minute break here and we'll start with 474.